County, we lost a legend in Glenarden and in Prince George's County, the Honorable Reuben Reed, who was the former mayor and council member for the city of Glenarden. So we want to remember him and all of his contributions to Prince George's County. He was a pioneer in that community, so we want to remember him as well. We want to remember Cornelius Weeks Jr., 92 years young, who was fatally struck in an apparent hit and run on February 7th. Nathaniel Jones, age 93, who was a civil rights lawyer and federal appeals court judge. He was general counsel of the NAACP in the 1970s and challenged school segregation in the North and racial bias in the military. Gene Reynolds, age 96, Hollywood writer and director behind the TV series MASH, Room 222, Lou Grant, Alfred Hitchcock Presents, Hogan's Heroes, and more. Orson Bean, age 91, all of these people made it to their 90s, for the last four anyway. Tony-nominated actor, magician, and stand-up comedian, best known as a panelist on To Tell the Truth. Robert Conrad, age 84, known for his TV role. He was actor West, I forgot his first name, but he was known for his TV role in the Wild Wild West. Jane Millmore, age 64, Emmy-nominated writer who wrote the sitcoms The Hughleys, Martin and Wayans Brothers, and wrote for Bob Newhart, Jamie Lee Curtis, and Martin Lawrence. Raphael Coleman, only age 25, star of Nanny McPhee, who was a climate change activist. Paula Kelly, age 77, Emmy-nominated actress, dancer, and singer who became a leading black Broadway performer in the 60s and also performed with Alvin Ailey Dance Company, known for her role in The Women of Brewster Place. Joseph Shabala, age 78, who was a South African singer and founder of the group Ladysmith Black Mambazo. Now, many of you, or some of you, may have had a loss in your family, and if so, we remember you and hold you close to our hearts as well. May we have a moment of silence, please? Thank you. I would also say that, it is, obviously we're in February, it's Black History Month. We have programs back there in the back of the room. We have amazing Black History Month programs that are sponsored by the Maryland National Capital Park and Planning Commission, and we would invite you to participate in some of these programs. There is a Bourne Bar Association oratorical contest that will be held right here in this hearing room on Saturday the 29th. We invite you to participate in that, to see high school students prepare speeches and participate in this oratorical contest and win scholarship money to help them with college. The Planning Department Black History Month program will be right here on February 26th. It is American Heart Month. It is Teen Dating Violence Awareness Month. It is imperative that we are cognizant of the prevalence of teen dating abuse. And it's like 1 in 3 or 1 in 4 teens will say that they have been subjected to some form of unwanted touching or some form of abuse in a dating context. And yet when you check with most parents think, oh no, that's not my kid. We need to be cognizant of the signs, and there is a huge Teen Dating Awareness Summit tonight, which will be held at Camelot on Route 114, that involves the State's Attorney's Office, the Park and Planning Commission, and so many other entities, social services, family services, and a lot of teens. I participate in this every year, and to see those teens get up and talk about what they have been subjected to, and it's girls and boys, will tug at your heart, will break your heart, and remind you that we cannot sit back and allow this to happen. It is also Library Lovers Month. Again, it's, so February 12th, I will just say that we had a couple of things. Abraham Lincoln was declared the President of Washington, D.C. on February 13th, 1861. Jesse James, 1866, held up his first bank. The exotic dancer, 1917, the exotic dancer Mata Hari is arrested in Paris on suspicion that she was a German spy. The 1920, on this day, February 13th, 1920, the National Negro Baseball Leagues were organized. The Wright, on 1948, the Wright Flyer, which was the first plane to fly, returns to the United States from England. And the Wright brothers actually flew out of the College Park Airport, which is owned by Park and Planning Commission and is the oldest continuously operating airport in the world. February 13th, 1957, the Southern Christian Leadership Conference was organized in New Orleans with Martin Luther King, the Reverend Dr. Martin Luther King Jr. as its first president. And then, let's see, 1996, rapper Tupac Shakur released his fourth studio album, All Eyes on Me. And on 2000, the last original Peanuts comic strip appeared in the newspapers. It was one day after the creator, Charles Schulz, died. So those are my items of interest. I will tell you, we are foodies up here for the most part. I'm not calling any names. But it is National Barley Month, National Canned Food Month, National Cherry Month, National Snack Food Month, and Great American Pies Month, and National Hot Breakfast Month. The February 13th is also it's the day before Valentine's Day, so 13th is Madly in Love with Me Day. So just remember to love yourself, and then of course tomorrow is Valentine's Day. Happy Valentine's Day to one and all. We're going to yes.
I would just like to take a moment to commend our staff on the programs around Black History Month and encourage folk to really get out and see and participate in some of the activities. I attended several over the weekend in Mount Pelion. They have a quilting display, and so many people don't know about quilting, but there was a time when people made quilts all over the United States, and so they did a national search for quilters, and the display is absolutely amazing. So I would encourage all of you to try to get out to see that display. It will be there all month, and we had some of the folk come from all over the country participating, and the quilts are just absolutely amazing and beautiful. Nothing that I can do, but something that I really do appreciate, and so I would encourage you to come out and take a look-see.
Thank you, Madam Vice Chair, for saying that. You know, and what's really amazing is we also had the opening of our Black History Month exhibit, which is down at Harmony Hall. And it's so crowded. These have grown so much over the years, and the exhibit will continue because it focuses on Black women from the ballot to the ballot and beyond. And so it will continue not just for Black History Month, but for Women's History Month. And we have all the pioneers there and the women who paved the way nationally and in Prince George's County. And we have many in Prince George's County, including Madam Vice Chair here, and many of whom paved the way for people like me to be in this position. So we have to keep lifting one another up. But it's a beautiful exhibit. And what was amazing to me for the opening ceremony, the county executive, Angela Brooks, was the keynote speaker. And they're always crowded, but this time it was so crowded that we had to have an overflow room, and the overflow room was so overcrowded also, so there wasn't enough room for the people in the auditorium and the overflow room. And it was just amazing, but everybody said it was spectacular, and we love to see the involvement of our residents in Prince George's County. And then, of course, this past weekend, we had Expressions of a People, which is annual, and that was very crowded as well. They're just amazing programs, so we really invite you to attend. Back there where Mr. Stone is standing, I'm sure there are some exhibits back there. So there are more to go. We have before
Madam
us...
Chair, if I may, and one of the trailblazers herself is Madam Chair in terms of being the first female, first African-American head of the Maryland National Capital Park and Planning Commission. So that shows what the trailblazers did before and what we plan for the future.
Thank you. Thank you so much for that. A little bias over here. Okay. So we have before us is anyone here to oppose the staff's recommendations on items 4A or 4B, or any board member wishes to discuss these items?
Move approval, Madam Chair.
Second?
We have a motion and a second. Is there any discussion? All in favor?
Aye.
Opposed? The ayes have it. We have a couple of items that will be removed from the agenda. Item 6 was a waiver of the rules of procedure, which is no longer needed because it was actually been completed. So there will be no item 6, waiver of the rules of procedure, on the agenda. And the same thing applies to item 8 and item 9. The request for reconsideration for item 9, Forest Hills Preliminary Plan 4-03071, has been withdrawn. So therefore, there's no since the request has been withdrawn, the waiver request has been withdrawn as well. So item 8 and item 9 will be removed from the agenda. We now have an item 5, I believe we have a request for a continuance, and then we will go to item 7, and then
Madam
followed
Chair.
by 3A.
Madam Chair, Andre Checkley, Planning Director. If I may have a minute, we have a couple of new staff members
Okay.
that we would like to introduce to the board today. Acting Division Chief Katina Schuler will introduce them from Countywide.
Thank you.
Good morning, Madam Chair, and members of the board. My name is Katina Scholars, Acting Chief of the Countywide Planning Division, and I'd like to introduce you to 2 new additions to the Planning Department. First, I'd like to introduce Judith Howerton. She is a senior planner. She'll be working in the transportation planning section. She comes to us from the city of Greenbelt, where she worked for a few years as a community planner too. She has a bachelor's in government and politics from College Park, University of Maryland College Park, and a master's in city and regional planning from Morgan State.
Well, and what was your last name again? Okay, thank you. Yes, I knew that. You can come. You can take a moment.
Howerton.
Okay, thank you. Thank you and welcome. We're pleased to have you.
Next, we have Bobby Ray. He is a master planner, and he will be working specifically with the special project section, focusing on oversight of the mandatory referrals. And he comes to us from the city of Rockville. He's worked there for the past 10 years. He has a bachelor's in sociology and history and a master's in regional city planning, both from University of Oklahoma. He's also worked in jurisdictions in California and Texas, and so he brings with us over 30 years of experience, and he will be working closely with me and also, like I said, the special projects section, and he has an extensive history with, extensive experience with development review as well.
Wonderful.
That's great.
We're pleased to have.
Thank you.
We're pleased to have you both to join us, and I'm glad you came on over from Rockville. Okay.
Welcome.
Welcome. And Madam, is there anything about Dr. Stabler? Did you run that?
Do this at our staff meeting, but I'm
Okay.
happy to, is she in here? No, she's not.
That's okay. We'll tell her.
Dr. Stabler, Jennifer Stabler, she was a planner coordinator in the Historic Preservation Unit. She has been promoted to master planner. So we're very excited about that. It's well-deserved.
Wonderful. So we'll congratulate her too. Thank you. So now we have a request for continuance for item 5.
Good morning, Madam Chair, members of the Planning Board. For the record, Sherry Connor with the Subdivision and Zoning Section. Staff has been made aware that the applicant would like to request a continuance in this case in order to provide more time to provide additional information based on some new environmental findings that have become prevalent in this case. Thank you.
Thank you. Are there any questions of Ms. Connor? Okay. Thank you, Mr. Rivera.
Good morning, Madam Chair, members of the Planning Board. Thank you for the updates on social news. I ate some spam this weekend, so I accidentally joined in the fray on that one. My name is Norman Rivera, here representing the Fairways. This is a purchase of the Glendale Golf Course that closed last year around Labor Day. We bought the course, filed a plan to redevelop it, a subdivision plan that'll be followed by a detailed site plan. So we've been going through the communities, Glendale Citizens Association. You got a letter last night from Mr. Wixon, because I notified him that we were asking for a continuance, so he didn't want to come up, bring his people. So he was notified. He sent your office a letter last night,
Okay, so
and I spoke to him. I think Ms. Lee has your letter, that letter. So he's in a concurrence with the continuance.
The letter came last night, so therefore we will mark it and accept it into the record as, I don't know whether they're opponents or proponents, so I'm going to just call it Citizen Exhibit Number 1. And they, indicating, and it's signed by Henry Wixon, and indicating that they are not opposed to the request for continuance. Now, did you give a date specific?
Yes, first of all, we would have to grant a 70-day waiver of the
Okay.
review period to
Thank
get to
you.
March 12th. And back to Mr. Wixon, the Glendale Citizens Association typically does not render a formal position. They want to be informed, kept aware of all the proceedings, and if and when they want to speak, they will come down and speak. So that's their practice, so I told them I would make sure that was clear. We have met with other members of the community. In fact, last night at the firehouse, we had a meeting attended by probably 40, 50 people, as well as Chairman Todd Turner. Some of those folks are behind me to the right, and they would probably like to address the board. We did explain to them that the board has to vote for a continuance, so I can't guarantee there's a continuance, but we have requested it. And normally it is granted, but feel free to speak on the continuance and anything else that's relevant to the case. So we've met with lots of them before. We gave them copies of the staff report. They have the website. They've signed up as parties of record so they can be part of the process moving forward. We did notify folks as far back as March of 2019 with the pre-application mailings, and in November when we got accepted, 2 more mailings. And Todd Turner,
Let me make sure, okay, so March 19th was the tell me, go through these dates for me.
yes, back in March 2019, by county code, when you file an application for a subdivision or site plan or zoning map amendment, we're required to notify any municipality within 1 mile. In this case, it was Bowie. We appeared before Bowie on December 2nd of last year. We're also required to notify any adjoining property owner. Some of the folks here from Glendale Forest, which is across the street from the golf course entrance on Prospect Hill Road. However, their association was not registered. So Mr. Turner pointed that out. You have to get registered, and I think they're in that process. But nonetheless, they are notified individually for those who bordered the property. We also notified all the other adjoining property owners in the area, as well as the other homeowners association, and that's on the record.
Okay,
But they're here to address the board. We told them we'd like to keep working with them, and this opportunity will give us that.
okay. Thank you. Are there questions of Mr. Rivera at this time? Okay, we have a number of people who are signed up. Right now, we're just addressing the request for a continuance. Okay, and what was the date? I know you granted the waiver. What was the date?
I'm working with staff, March 12th.
March 12th, okay.
Yes, thank you. ma'am.
Okay, so I have a number of people signed up. Right now, we're not addressing any substance of the case. We just want to know if you, obviously, the applicant has done the mailings, and they're indicating that they'd like the opportunity to meet with citizens. We have the Glendale Citizens Association. I'm hoping that, indicating that they would prefer to meet with the citizens as well, to meet with the applicant as well. When I call your name, if you are in agreement with the request to continue this to March 12th, please indicate by saying yes or no, or you can come to the podium to say yes or no. Charmaine, Gunter? You're in agreement with the continuance for them to meet with you? Thank you. Please let the record reflect that Ms. Gunter is present and does agree to the continuance to March 12th. Is it Kendallin Hodges Simmons?
I will not be able to appear on that date, so if I have an opportunity to present my testimony to someone else, I'm agreeing.
Okay, so okay, because right now you're not being recorded, but let me just, what I hear you saying, because I'm going to repeat this for the record, is that you may not be opposed to the request for continuance, but you are not available on the date of March 12th. But what you do have the opportunity to do is to submit a letter into the record, or if you know of someone else's, you can submit the letter into the record in advance, or if someone you know is coming, they can bring the letter for you, if that helps you.
Yes, that helps.
Okay.
So we're not in opposition.
Okay, so I don't know who the we is, but it says Kendallin Hodges Simmons. Okay, thank you. So she's not in, she's okay with the continuance to March 12th. Cicera, is it Sierra? It's Cicera. Cicera, okay, I'm sorry. Cicera, that's what I thought, Cicera. Denier? Daniel, okay. I'm trying to read people's handwriting. Okay, sorry. Are you okay with the request for a continuance to March 12th? Yes. Okay, please let the record reflect that Ms. Daniel is present and does agree to continue this matter until March 12th. Mirabelle Asengang?
She's left.
I did? Okay. Are you okay with the request for a continuance? Okay, let me stop you for a second because your conversation is starting to be more substantive, so I want to get you on the record. If you can come to the microphone. Do you belong to another citizens association? Yes. And what citizens association is that?
That's Glendale Parks.
Glendale Parks, okay. And that's the one, Mr. Rivera, that you said it was not registered with us?
Correct.
Okay. Okay, please state your name for the record.
Mirabella Sengo.
Okay. Okay, so I was close, okay. I think I hear you saying you're not opposed to the request for the continuance, but you are saying that your association didn't get the notice?
We didn't get the notice. Our residents who actually bother the proposed redevelopment, didn't get any notices as well. When they keep mentioning Glendale Citizen Association, it does not speak for all the residents.
Right. And what I think I hear Mr. Rivera saying is that not every association is registered. And we make this announcement because we have someone sitting here in the audience today who was very instrumental in ensuring that residents got pre-acceptance notice and that the registered homeowners associations got notice. But you have to be registered. Now, Mr. Rivera is indicating that your association is not registered. And if that's accurate, I'm going to have Mr. Hunt right there, Mr. Hunt, speak with you just to make sure that it's not registered, and if it isn't registered, that you will be registered. And it's imperative that every association maintains current information, so that if the president changes, we don't want the past president. I'm not accusing accusing anyone, but if someone is no longer in office or they move away, we don't want it to get lost or get in the trash or something. We want to have current officers and current mailing addresses for notices. So Mr. Hunt is going to speak with you to make sure that your association is registered so that you too will get notice.
So the question is, when it's stated that properties bordering this development
Correct.
were notified, if he did say they notified individuals as well. So
They have to be is your
Adjoining.
property adjoining? Okay. Okay. Well, Mr. Rivera, can you confirm that, because we don't have, because it's a request for the continuation, we don't have the PowerPoint up on display for us to see where your property is vis-a-vis this application. So if Mr. Hunt can pull you aside for a second, and Mr. Rivera can pull you aside to confirm well, you know where you live, I'm not questioning that, but to the proximity to this application to make sure that she is supposed to receive notice. And now you will have the notice that if it's continued, it'll be continued until March 12th. So you will have notice when to come. And if your association would like to meet with the applicant prior to that time, you can make your request right now, and then they will be happy to come to meet with you.
But the thing is, Mr. Rivera represents.
To the microphone, please.
I'm sorry. He represents. He's a party of interest for what he represents. So it's not like they have what they want. We have our demands. So we feel like this is the place where we can make changes, not with them, because if we are opposing.
Okay, but
How?
But you can, okay, I don't want to, because right now we're in a request for a continuance. But what I am saying to you, a conversation with them ahead of time is never a bad thing. It's never a bad thing for them to show you what they're proposing, for you to raise your concerns and ask your questions, which you will still have the opportunity to do once you come here. You absolutely have that right.
Yeah, we've
But-
done that. I'm
Okay.
sorry, I'm sorry, I cut you off.
So you've already met with
We've
them.
met with them. Last night, we actually met with them, and we're still trying to get
So
more
how did you
people.
know to meet with them?
Bowie notified the residents,
Okay.
which is the concern, like, why was Bowie the one notifying us?
Because because they're saying your association isn't registered. Are you registered?
The association isn't registered, but Bowie notified us, so why is there such a discrepancy? If the county can notify us, but a city is, how?
Because the law says if a registered association, just get your association registered. That's an easy thing to do. All you have to do is sign up with us, and then you'll get notices.
Yeah, they notified us personally, just as I'm saying, bordering properties. So
Okay.
we got notified personally, which is a concern that the county didn't do such a thing, yet a city did that. So I guess it's something whereby the law is so lax that people can go around it, because
I don't know that anybody went around it. You're not demonstrating to me that anybody went around it. You're standing here and you're saying, there are two types of notice. The notice to the property owners that are adjoining the site, and that we have to look into, because you're saying you're an adjoining. I mean, really, you have the common border, okay, that you're adjoining, okay, and then, so that's a separate issue from the association issue. So the association issue, if you're not registered, we have to count on those associations that are registered. And so if you just sign up with us, then we can take care of that issue. The other one we need to look into. But you will have that opportunity to come before us on March 12th. If you cannot be here, you have the opportunity to submit comments. You also have the opportunity to ask questions of our staff at any time beforehand. You also have the opportunity to meet with the applicant in this case, which is never a bad thing, because when with the exchange of concerns, sometimes there is give and take, and sometimes there is give and take that we cannot impose, because we have to make our decisions in accordance with the legal parameters of concerning the planning board and the type of application. But sometimes citizens can talk with the applicant, and the applicant hears your concerns and sometimes makes some concessions, sometimes not. So I would advise you to go ahead and have a meeting with them but you said you had one last night.
yeah. Last question then. The pre-approval that came from Parks and Planning, were the residents able to make comments on that?
What's the pre-approval?
The report that was just submitted.
The technical staff report?
Yes.
So that's our planners, our professional planners analyze the application. After they receive an application, they send notices to municipalities, to the Department of the county, various departments of the county, such as Department of Permitting, Inspections and Enforcement, Transportation, DPW&T, State Highway Administration, a whole host of entities, and then they send reports back, police, so many others send reports back, and then the technical staff person has to synthesize all those reports, do their own analysis, and present it in a staff report, which is then available online for 2 weeks, and citizens have the opportunity to download it and review it, and that is their recommendation. That is not their it's not the final decision.
Right.
This board will make the decision.
Okay, so we still have a say on what they said on that report.
Yeah, you have, when you come to the hearing, you get the opportunity to talk about that, and you can say, you know what, I agree with this, I don't agree with that. You have the opportunity. Do you have a copy of the staff report? Okay, so you have, it's your right to come before us, and to comment on the technical staff report, and to comment on your position with regard to this case. And it's your right to meet with the applicant as well. It is a preliminary plan of subdivision, and so we have legal parameters that we have to consider. So, but it's all set forth in the staff report. But the decision is yours to make. But I think it's always a good idea to have that meeting. And are you saying the meeting wasn't productive at all last night, or what? Okay.
Have another
Okay.
one.
Madam Chair,
Okay.
Madam Chair.
So I'll just add a couple things to
Okay.
Madam Chair's comments. So when we get people from the public who have opinions, our staff reports don't say like this organization met with them and here are their opinions or anything like that usually. But it's sort of implicitly baked into there that a lot of times there are multiple stages throughout the process for you to get involved. So before I was on the planning board, I was on a city planning board, and we would make recommendations to the city. We would have HOAs and civic associations come to us, and that would actually get incorporated into our comments, which later on got actually fed up into this board before I was on it. So sometimes those comments will be embedded in there. You can always reach out to our staff, and then if there are concerns that like they didn't know about or they weren't thinking about, that sometimes implicitly kind of gets baked into our reports as well, and they can bring up those issues. So getting involved early is the ideal thing from our standpoint, because then we don't have a 2 or 3 hour session coming up, and we're having to kind of decipher all of these issues out at the moment when we have to make a decision. It's always helpful to kind of have those conversations going back and forth between you and our staff, or you and the applicant, or your organization and the applicant, before it comes up before us, because then you can work out these details. And these attorneys typically are repeat people who come up here to represent other developments throughout the time and different weeks. So they know that they have to get involved, because if they don't talk to the applicants, we will make them talk to the applicants down the road, because they will always come up, and we will continue to sort of pester them to make sure they are involving the communities. So I think you'll be hopefully pleasantly surprised that when you talk to Mr. Rivera, that you will get some, if not all of your issues addressed in some fashion. And then our staff can also be really helpful, because this will be a multi-stage process. And as a citizen, if you're not an attorney or you don't do this on a regular basis, it can be somewhat intimidating, because you don't know what you can ask for at different stages, and you don't necessarily know what we can, on our side, we can actually ask the applicants to do. Our staff can help navigate that process for you. So they can tell you at this stage, these are the things that the planning board will consider and that you could ask in your testimony or comment about in your testimony. Here are other stages where you can address those concerns as well. So certainly reach out to our staff, because they can help you kind of figure out what you can or can't do in different parts of the process. Yeah.
Thank you.
And thank you for coming.
All right, thank you.
That's wrong. Okay. Thank you. Yes?
You have to,
Okay, please come to the microphone, but this is on the request for a continuance. Okay.
So, and since it was
Please
on the...
restate your name for the record.
Cicera Daniel.
Okay, thank you.
Since it was on the request for a continuance, I just responded yes, but I would point out that there's one other category of resident in this area. The cul-de-sac that I live on, it does immediately border this development. We don't have a homeowners association.
Okay.
If I got a notice from Bowie, I wouldn't have paid attention to it, because
Okay.
I'm a resident of
Were there
Glendale.
no signs on the property indicating the hearing?
I found out about the meeting last night,
Okay.
literally through word of mouth.
Okay.
So maybe I take a way out of our
Okay.
development. But
Okay.
I know it was on a request for a continuance. I'm an attorney, but I know nothing about zoning and land use.
Okay.
It is all very confusing still. That is something that I just want to make sure is of record, that there are a number of neighborhoods right around this development that don't have homeowners associations. Didn't even know about the civic association until last night. We recently moved to the area.
Okay.
Thank you.
We thank you for your comments. And where's Mr. Hunt?
Right
Oh,
there.
he's over there.
Ms. Daniels.
Yeah, Ms. Daniels.
Daniel.
Mr. Hunt, see Mr. Hunt in the back there? And he'll talk with you too, but just to confirm where you live. And Mr. Rivera, we'll make the opportunity to.
Yes, we met last night, and she's on our mailing list as an adjoining property owner.
Okay,
So we sent her one in March and 2 in November, and met her last night. But even if you're not a registered HOA, but you're adjoined, you still get a letter. But we've exchanged numbers, we'll
okay,
continue to
so
work
there's
together.
some question as to whether she got it. Now, of course, these letters are removed in time because there's the pre-acceptance letter, which was months and months ago. So anyway, if you take the opportunity to talk with Ms. Daniel and Mr. Hunt, we want to make sure we get that straight, okay? Was there anyone else who's, Lowell? That's what I was going to say. Lowell, are you in support or opposed to the request for a continuance? You'll support? Okay, now. Can you say your last name again?
Blagman.
Okay, I'm telling you, this says nothing like that. Okay, Blagman. Okay, Okay.
Just as a point of clarification, Madam Chair, when people sign up and they come to either oppose or support the continuance, they do go on as a person of record where they would get
Yes.
mail-ins in the future
Right.
about everything related to this case, right?
For the preliminary plan, and would that continues with the site plan and things of that nature too? Okay, yes. So please let the record reflect that Lowell Blackman is here, is present, and does support the request for a continuance until March 12th. That completes my sign-up list. Was there anyone whose name I did not call? Is there a motion to continue to March 12th?
Madam Chair, I move that we continue to March 12th.
Second?
We have a motion and a second, and under discussion, please let the record reflect that the applicant has granted a waiver. Did you do that in writing?
No, I did it for the record, Norman Rivera. I was said I could do it on the record
Yeah, I
today.
know you did it on the record, okay.
I can follow up with a letter if you wish.
Okay, thank you.
Thank you.
So that, there is a 70-day waiver that's been granted by the applicant. All in favor?
Aye.
Opposed? The ayes have it. Mr. Rivera, please make an effort to meet with the folks who have shown up today saying they did not have an opportunity to address their concerns fully. Okay, I'm going to pass this. Okay. Okay. Okay, so I'm going to take a minute, and then we're going to come back with item 7. Thank you. Okay, item 7. Okay.
Good morning, Madam Chair and members of the board. For the record, I am Thomas Sievers, Senior Planner with the Subdivision and Zoning Section. Item number 6 and 7 are related. However, item 6 was removed from the agenda as the waiver to the rules was approved at the November 21st, 2019 Planning Board meeting. Item number 7 is a reconsideration request for preliminary plan of subdivision 4-18007 for Woodmore Overlook Commercial. The preliminary plan was approved on March 7th, 2019, and the resolution was adopted by the Planning Board on March 28th, 2019. During the November 21st, 2019 Planning Board meeting, the reconsideration could not be heard because an appeal held the case in the Circuit Court. In a letter dated December 31st, 2019, and received January 17th, 2020, Norman Rivera, representing the applicant, requested a reconsideration to amend Condition 6A and to delete 6B based on good cause. Condition 6 relates to the provision of required transportation adequacy improvements as found in the preliminary plan of subdivision. If the reconsideration request for the preliminary plan is granted, staff will provide a further analysis on the merits of the request at a later Planning Board hearing. This concludes staff presentation.
Okay, thank you. Are there any questions? Okay, Mr. Rivera, you're on.
Good morning again, Norman Rivera for the record, representing Woodmore Overlook Commercial LLC. Thank you, Mr. Sievers, good to meet you.
Microphone, you're not.
Oh, I'm sorry.
Thank you.
For the record, Norman Rivera, representing the applicant, Woodmore Commercial LLC. Thank you, Mr. Sievers, good working with you. So you're fairly new to the staff, fairly new to me. Thank you, Madam Chair and the board for the waiver of the rules before, and as the chair stated, once there was an appeal, we lost jurisdiction, or you lost jurisdiction. The case went to the circuit court. The circuit court reviewed the case, dismissed the case, and they also did not grant Mr. Benton a reconsideration of his request to reconsider the case. So we're here today on the merits of the actual reconsideration, just the reconsideration request itself. And if the board grants reconsideration, it gives us the opportunity to come back after working with Mr. Mazog and your other staff on the merits of this very technical issue. And just to get to the technical issue, when the CSP was approved for the overall property, it had a larger footprint and square footage of development. When we went to the preliminary plan, which is before a DSP, it reflected that larger square footage. However, by the time we got to DSP, the development window shrunk, so the square footage, which creates the trips, also commensurately reduced. So the reconsideration request is to allow us the opportunity to work with staff. They know that the trips are reduced, therefore certain improvements aren't necessary or can be modified. So I believe the staff is here to address that issue, but that's on the merits. But we wouldn't be here if they didn't agree that there was some logic to our request. So we respectfully request the board grant the reconsideration, then the staff can conclude their review, and then bring it back to you on the merits of the case.
Okay, does the board have any questions of Mr. Rivera at this time? Okay, Commissioner Dorner.
So the request is being made on fraud, mistake, good cause.
Good call.
Yes, good cause at the end.
Thank you.
Thank you.
Okay. Are there any other questions of Mr. Rivera at this time? Okay.
Thank you.
Mr. Stevens, did you have anything else to add on this? I have people to call, but,
No, ma'am.
okay. So, Mr. Dean?
Good morning, Madam Chair, Vice Chair. For the record, my name is Samuel H. Dean. I live at 10710 Willow Oaks Drive, Mitchellville, Maryland. And I'm the Vice President of the Lake Harbor Civic Association, and I'm here in opposition of the waiver.
I just want to, we can barely hear you. I want to make sure the microphone is as close to you, or you're as close to the microphone as possible.
Yes, ma'am.
Thank
Okay.
you. Thank you.
This whole process, the waiver, really is to get over a decision that was made by the district council requiring this applicant to build a ramp over Maryland 202. One of the things that has really troubled me, and let me kind of vent while I'm here, we've gone through this process for the preliminary plan of subdivision and CSP relative to how this project is supposed to be developed. First of all, the MST was for Woodmore Commercial, really meant for Woodmore Overlook. And it was supposed to be an MXT, residential and commercial. The developer has come and said, well, we can't build commercial, so let's rezone this again to MXT. And I have an issue with that, but that's not the crux of my concern. The crux of my concern is that the developer really don't want to be forced to build this ramp. And in all of the legislation that preceded this, it was a requirement for a ramp. One of the things that has absolutely troubled me, and maybe you all can help me, I always thought that transportation and roads were determined by your transportation division. What I found is that the developer gave the county some land, and the county, through DPI, used that land to come up with a master plan road. The community had no idea that this was done. And the question for me is, what is the legality of that decision? And as a citizen, I would like to see the DPI's authority to grant a master plan road. What troubles me is that DPI grants a master plan road and then in turn approves it and permits it. To me, that doesn't smell right. So again, I would ask that the waiver rules will be denied and that the developer will have to adhere to the decision of the district council, where they would have to do a ramp. This is basically what this is about. Secondly, since we all started out with Wayne Curry, and one of the things we dealt with was housing, okay? And basically what is beginning to happen in this corridor, the 202 corridor study and Chairman Hewlett, you were the chairman at the time, said that we're going to build this corridor out in such a way that is going to enhance the county. The community, the homeowners association, ended up $14 million for road improvements. We in the county gave $17 million to Woodmore Overlook to build that center. Woodmore Overlook Commercial is coming and asking for 6 parcels. One, they're going to build a rental apartment on one of the parcels of 154 units. And then they want to build a Royal Farm gas station on the same property. We have an absolute large investment in that area, and we really don't need to have strip malls. There's another piece of property that is also have the same problem. What you all did was to allow the developer to go back and rezone the commercial to MXT. And remember, most citizens don't have a clue, just like the young lady was up here didn't understand this process. We expect you all to protect us. We're fighting the developer, and I don't have a problem with them. I know these individuals. But as a citizen, we deserve more than what we're getting. So my issue is that, one, how did DPI determine a master plan road? How did DPI then permit that road? And if you look at all of the legislation starting with 1987 on, it always said that there would be no access to Landover Road, Maryland 202. If it were, it would have to be a ramp. When I was on the council, I put in a piece of part of the legislation that required that they could not build a driveway at the intersection where they want to build a Grandway Boulevard. Your urban planner came back and said, oh, we're not building a driveway, we're not building a public road. The purpose of what I put in was to prevent any access to that area. So I'm really frustrated. And I've been at this business for over 30 years, and I'm tired. And I expect better from this planning board. What I would ask is that you deny the request. Thank you.
Are there any questions of Mr. Dean? We have some other people here to speak, and some of this stuff, I'm not sure that I can answer, but in terms of what DPI did.
But I would like from you, Madam Chair, if possible, for DPI to give me their regulation that says that they have the authority to determine master plan roads. I thought that responsibility rested with Park and Planning. Thank you.
Okay. All right. Thank you, Mr. Dean. Are there questions of Mr. Dean at this time? So actually, we don't determine what's a master plan road, but I'm going to have Mr. Masog address some of these issues after we finish with one or two more speakers. Okay. Well, actually, Mr. Reniger is here but does not wish to speak. Okay. Okay.
All I'm asking for, remember, you all have, based upon your positions, there are certain authorities given to you. All I want to know is give me the legislation or regulation where DPI has the authority to determine master plan roads, and then the authority to permit the master plan road. When I was a civic leader before and on the council, never heard of it. This is new to me. Now, I'm not saying that it's wrong, but I have a hard time, accepting the fact that there's a conflict of interest when I can give you something and then I can approve it.
Okay, so, Mr. Dean, let me say this. You know better than most people what our authority is, and what I think I hear you saying is, even though that may not be under our bailiwick or purview, that we may have the authority, we may have the juice, so to speak, to request of DPI how they were able to do this.
And again, I don't want to beat to that. Every transportation issue came from your transportation division on how we're going to build roads in the county. I was here with Department of Public Works and Transportation, and when Department of Public Works and Transportation, when you all wanted to build a road, the roads were permitted. They did not determine a master plan road. They went to your transportation division, and the transportation division laid it out.
Okay.
And I went to your master plan of transportation, and there is no such road as Grandway Boulevard. Grandway Boulevard became a master plan road because that's what DPI decided was gonna be. And I'm really livid because basically what you're all beginning to do in that corridor is to bring low-end development, okay? We spent a lot of money to make sure that we had quality development. And what we're beginning to do is get crap. Let me be clear. A 154-unit rental and Raw Farm gas station, and we just spent $17 million to bring in a Costco. And within a less than a 2-mile radius, we have 5 gas stations. It's not that much gas needed anywhere.
I don't want to keep debating on this issue because we've heard your position on the request, but you will know when the council imposes a zoning, and if the gas station is consistent with that zoning, then we cannot just say no to a gas station on that basis, because if it's a permitted use in that zone. So, and the number of gas stations is irrelevant. It's not a test that has been enacted by the legislative body. So
You're singing to the choir. I
Yeah.
understand that.
Okay.
Okay?
so
I understand that. However, you do have the authority for zoning. You,
we no.
wait a
the
minute, wait a minute. Someone comes to you for a preliminary plan of subdivision, right?
Right.
You approve it, right?
That's a preliminary plan, but
Okay.
not the zoning. You said
Well,
zoning.
CSP, you approve it. And what I'm saying to you is that we started out with MXT for Woodmore Overlook. Woodmore Overlook Commercial was to be one 5-story office building with 2, I think 3-story office building. They came back and said, we can't build office. We have a glut of space. You have another project coming along pretty soon on the same property. However, they do have an opportunity because it's MXT, and as you said, you can do whatever you, MXT allows. And so we're going to build a 154-unit rental apartment within a 3-mile radius. I know you can't control what happens once you approve a project, but within a 2-mile radius with Carillion coming in, we're going to have over 6,000 rentals.
6,000 what?
6,000 rentals.
Rental. Okay.
I don't think we need that.
Okay.
So anyway, I'm frustrated. I really didn't want to come down here, but I am absolutely frustrated as to what is beginning to happen in the corridor.
Okay.
We deserve better. Thank you.
Thank you.
Thank you.
Okay. Mr. Benton.
Good morning, LaRae Benton for the record, 1731 Stourbridge Court, Mitchellville, Maryland. Just to clarify a statement that Mr. Rivera stated, pretty much the preliminary plan is currently has been appealed before the Court of Special Appeals. So that's where that currently is. Mr. Rivera is coming to you today with a request for consideration. Based off of Section 10, subsection E of your plan, of your rules of procedures, pretty much, the basis in which you can only grant a consideration is based off of, one, in furtherance of substantial public interest. So substantial public interest has to be weighed. In addition to that, you also have to find that there was an error in reaching the original decision of the board.
No.
Oh, okay.
It's fraud, mistake, surprise, inadvertence, or other good cause.
But no, I'm just reading. No. I understand that's on there.
I thought you were saying we have to, in addition, that we have to find error. We don't.
No. That's fine. I'm just reading what it says. I do understand.
Okay.
That's fine. All right. So one of the primary arguments that Mr. Vero, the applicant, is using is that pretty much you can actually find, pretty much the board can find good cause to actually permit the reconsideration. In his letter, he actually stated that there is no legislative definition for other good cause, right? However, there is a lot of legislative case law that actually supports and define what actually good cause is, right? With that being said, in terms of how the Black's Law Dictionary defines good cause, pretty much it's a legal term denoting adequate and substantial grounds for a reason to take a certain action or decision, right? So right now, the planning board, you have to find good cause to actually permit the actual request. From Mr. Rivera's letter, the only good cause that he has stated was that pretty much not that the district council or the planning board changed any of the conditions of the approval, right? The only thing that he stated is that the developer wishes to do something different that is less than what's currently approved, right? What's currently approved right now is per the conceptual site plan and also per the zoning map amendment. What's currently approved right now is for the ramp or the flyover to go over connecting the residential side of 202, right, with the I would say the commercial side of 202, but pretty much that's where a lot of the seats in the head of the county government currently sits right now, right? So that's what's currently approved. So that's actually the standard, right? Now, in addition to that, what the planning board must also consider is a part of the argument of good cause, all right? All through a part of the argument of a good cause, right? It's littered in Maryland law. It's littered in Maryland case law, right? But also, it's actually put in the zoning ordinance, right? So, if you actually turn to, or even if you consider section, here we go, section 24 of the zoning ordinance, subsection 104, right? The first thing it does is in subsection A1, right? The purpose of the subtitle, which is the subdivision subtitle, right, is to protect and provide for the public health, safety, and general welfare, right? So again, the good cause order, when you look at the good cause argument, you have to consider what's in the best interest of the public, not necessarily what's in the best interest of the developer, right? Now, as what the developer is actually proposing is simply this. You have a current standard, right? To whereas the district council and this board has required, all right, the developer to actually build the overpass connecting the two sides, right? And in building that overpass, it would conform to what the zoning ordinance says here in section 1 in terms of providing for public health and safety, right? Because right now, building that overpass, right, and building an overpass, you're going to have vehicular traffic, but then also, you're also going to require them to also provide some pedestrian sidewalks so that residents can safely cross from one side of the 202 to the next, right? Because we all know that in that particular area, it's a safety hazard for pedestrians to have to walk across 202, either at Landover Road and 202, or at St. Joseph's or McCormick Drive in 202, right?
Let me stop you for a second, because here's the thing. We have already granted the waiver, so now this is the request for reconsideration. No.
I'm sorry.
The request for reconsideration, which, if granted, will enable the applicant and our staff and you and anyone else who's interested, well, and a party, to address the substance. And so what I think if I'm not mistaken, I think I hear you addressing the substance of the last decision at this juncture. And what you're making arguments about the subtitle 24, which indeed contains the subdivision regulations, and you're tying it into the changes that the applicant wants to make, but we can't hear all that unless we get to the actual reconsideration hearing.
Understood, and that's not what I'm arguing.
Okay, so
The point
help me
I'm arguing is simply this, right?
Okay. My mistake. I thought you were mentioning subtitle 24 and.
No, I did,
Okay.
but it's actually to support my argument of good cause, all right, and how evaluation of good cause, all right, should be legally assessed,
Okay.
right? Because according to your rule, you can only grant a reconsideration if the original decision was caused by fraud, which hasn't been alleged right now, surprise, which isn't alleged, mistake, which isn't alleged, inadvertence, which isn't alleged. The only thing that has been alleged was good cause, right? And all I'm saying is, in making your decision of good cause, I'm just supporting making the argument that the standard of actually determining what good cause is what's in the best interest of the public, right? As it is now, right? Not what's in the best interest of the public as the developer desires, right? But what's in the best interest of the public as the site is approved according to the zoning ordinance and planning board rules today, right? And what I am saying is this: there is nothing in the applicant's argument in his request that actually argues and provides any evidence as to how their desired changes, all right, is actually going to further substantiate and pretty much in furtherance and substantial of public interest. So if you already have an approved standard that the district council and the board has already established, this is good cause as it relates to public interest, right? It's incumbent because they have the burden of proof. It's incumbent upon the developer to actually explain to this board, which they have not, because I haven't seen it or read it, to explain to this board how their changes actually either meet that same standard or exceed that standard in the best interest of the public, right? So that's pretty much my argument, because what they're arguing is not to build the overpass, but just to simply build a road connecting Landover Road and 202 with just a right in and right out, right? At the same time, that's a lower standard, right? That's a lower design than actually building the overpass as it is approved with the vehicular traffic and to connect the vehicular traffic and the pedestrian traffic from one side of 202 to the next. Because right now, the residential community in terms of the Bulk Hill Village, Woodmore Town Center, that community is right now divided and separate from the actual offices of Prince George's County, which actually represent us. By building that overpass, right, that actually permits the connection between both the residents or the constituents of the community and our county government, which I argue is in the best interest of the public. All right, if you don't by now allowing that overpass or that flyover to be built, right, that decision would actually go against the public interest. It would actually be in detriment to the public interest.
I think that's an argument, though, but I think, I understand,
Microphone.
I understand the point you're making, okay? And it's a valid point. But I think what you're arguing is really what needs to be argued at the next stage.
Right.
Because just because if we agree to the reconsideration does not mean that developer, what he wants to do will be approved. That's the point. And to the extent that there is a public safety issue, then that's something that should be argued at the next level as opposed to here,
Okay.
if the reconsideration is granted.
Okay. And my other question is, I question if the preliminary plan is currently before the Court of Special Appeals, do you even have the
Well,
jurisdiction?
let me ask you about that, because that's new information for me.
Yeah.
So is the preliminary plan before the Court of Special Appeals? Or
Yes.
is the circuit court's denial of, what?
No, it's been appealed to the court.
What has been appealed? I'm trying to understand. That's all. What specifically
Okay.
has been appealed?
The preliminary plan 18007, right? Obviously, it was in the Court of Appeals, right?
Was in the-
I'm sorry, the Circuit Court.
Circuit Court, okay.
It was in the Circuit Court. All right. Pretty much, my mother went in the hospital. I wasn't able to attend. All right. They actually dismissed the case. I submitted my request for reconsideration. All right, because I timely sent in a motion for continuance and all of that. But it was denied. I then appealed the entire.
The motion, I'm trying to keep up with you. So the motion for continuance prior to the hearing date on your appeal, prior to the hearing date, you filed your motion for continuance, and
Yes.
it was not granted prior to the hearing date.
No.
So it was not granted at all. So they went forward. You weren't there.
Well, no, I wasn't there.
Okay.
No,
I
my
understand.
mother's
I'm
in the
just trying
hospital.
to follow. I'm not saying you didn't have a good reason. I'm just trying to understand. So then you filed a request to reconsider. Is that what you're saying?
Yep.
And then what happened there?
The judge denied my request for reconsideration.
Okay. And so what is now on appeal? The denial of the request for reconsideration?
No, the general appeal. So the
What
baseline.
general appeal?
Okay, so what I appealed to the Court of Appeals, right, was the general fact that all of my arguments, considering that the preliminary plan was erroneous approved, right, pretty much on the basis and the merits.
I'm trying to understand whether you. Okay, so that may be your appeal. I think from that point, if the only decision you have from the circuit court is you have the denial of your preliminary, your request to, you have the denial of your motion to reconsider. So it seems to me that that's what is on appeal to the Court of Special Appeals.
Well, that is one part of it. I mean, the basis is I never had my day in court. So it's really a matter. It's really a
Okay.
matter of due diligence. I mean, due process. But
Okay.
in what I appealed, and part of my basis and within my brief of my appeal is simply that one, I was never given the opportunity to even hear my case. Right. So one, I didn't have my day in court. So really, my argument is one of my arguments is due process. Right. Two, I also appealed the fact of the judge denying my motion for reconsideration when I timely submitted a motion for reconsideration, provided evidence, even called into the court and told them, I'm in Georgia, I will not be in. So, I also appealed that basis.
When you said you were in Georgia, you will not be in, but that's following your written motion for continuance?
No, that was prior to.
Okay.
The case was on that Monday. I called in that Thursday and Friday.
Okay.
Prior to.
And then you did a written motion.
And then I filed a written motion. Obviously, if I'm in Georgia, I couldn't bring it in, turn it in.
Okay.
But that's what me and the clerk was emailing. I emailed the motion, and I actually had one of my friends formally here, I emailed to them, and they eventually
Okay.
brought it to the court, but
Okay, so your two your issues are good cause for this particular hearing, are that, do they meet the standard for good cause? And two, is this properly before us, given your appeal to the Court of Special Appeals?
yes,
Okay, that's what we needed to know.
okay.
Thank you. Are there questions? Okay, that concludes my sign-up list. I'd like to I'm going to turn to Mr. Masog. I'm going to turn to first, but before I do that, I'm going to turn to Mr. Rivera, because I'd like for you to address the issue of the Court of, and I'll turn to our own counsel as well. But your case, your burden, tell us about the good cause, and tell us about the, and the and were you aware that there was an appeal to the Court of Special Appeals?
No, ma'am. Norman Rivera for the record. We have no record of being served for any appeal. And if there was an appeal to the Court of Specials, it would be the appeal, I believe, of the judge's denial of his reconsideration request. They first dismissed the appeal on the merits, then he dismissed the appeal as to the reconsideration. So he possibly filed a reconsideration appeal to the court that the circuit court did not properly grant his reconsideration or improperly denied it.
What I was
That's
remiss,
not relating to the preliminary plan, though.
right, what I was remiss in asking was when this happened, because you should have been properly served.
We have no record. We have other attorneys on this case. Mr. Benton has filed several lawsuits against the district council and the Prince George's County Planning Board, and recently the circuit court dismissed all of them. But we have no record of any current pending appeal that is valid.
Okay. Mr. Benton, you don't have to get all the way up. I just want to know, when did you file this appeal, and when was Mr. Rivera's firm served?
The appeal was filed on December 19th, right? The party,
Okay. Can you give him the other microphone, Mr. Cosby?
so
I meant the other way.
my
around, but that's
original
okay.
appeal to the Court of Appeals was filed on December 19th. All right, it's case number CSA.
And when was Mr. Rivera served?
I served Mr. Rivera at the same time I served their attorney of record, who is James Harding. Mr. Rivera is not representing the applicant in circuit court, neither the Court of Appeals.
This
Attorney-
sounds like deja vu to me. Didn't we just have this discussion?
Yes, yes.
So that was the appeal to the Court of Special Appeals? Or
Yes.
Not the circuit court? Okay.
Yes,
Okay.
right. And I just want to read in the case number for the record. That's before the Court of Special Appeals. It's CSA REG -211 -2019. All right. That's the case number that's before the Court of Special Appeals. And again, Mr. Rivera is not the attorney of record in either the circuit
Who
court.
is the attorney? You said Mr. Hart. Who is Mr. Hart in your firm?
Jeffrey R. Harding is the
Oh,
applicant.
Harding.
Yeah.
Yeah, I know. Okay.
Jeffrey Harding, over on Water Street.
Yeah, okay.
He's the actual attorney of record representing both Woodmore Overlook and Woodmore Overlook Commercial.
So he got a notice in December, you're telling me?
He got a notice in December,
Okay.
and also since the planning board was a part of that, all right, Ms. Borden also got a copy of that notice.
Okay, thank you. That's what I want to know. Okay. Okay. Mr. Rivera, are you in communication with Mr. Harding?
Yes, but I'm not aware of that appeal.
Okay.
But it would not stop the board from proceeding, as far as I know. We're allowed to proceed at our own risk, and that's what we're doing today. The Court of Special Appeals relates to his denial of his reconsideration, if I understand him correctly, which isn't the planning board.
Okay, we're not going back and forth, sir.
Okay.
Okay, no,
Sorry with
Mr.
him.
Rivera, finish. What I'm trying to understand is the mere filing of an appeal does not act as a stay.
Correct.
But why was that so in the case of circuit court? Why was this continued once Mr. Benton indicated that he had filed an appeal to circuit court?
Well, that was a ruling by your counsel back in December.
That was okay, and so somebody needs to explain to me why this one is different. Why the appeal to the circuit court necessitated a continuance, but the appeal from the circuit court to the Court of Special Appeals does not. I just need to understand, so the record is
Well, I
clear.
understand what you're trying to get to.
Yeah, I mean, I would.
Sir, okay, you're not on the record. Okay, Mr. Warner, maybe you can help explain that, and two, and we, this conversation is somewhat deja vu, because I recall Mr. Benton saying before, when the appeal was noted to the court, to the circuit court, Mr. Harding's name came up, and Mr. Rivera, you were unaware of that, and so if this information is accurate, that Mr. Harding was aware of this in December, then that seems, mid-February that you should know about this too. So I'm trying to keep the record clear, trying to make sure we stay in our lane, trying to figure out what our parameters are. So I need for you to make that case, and I need to talk to Mr. Warner as well, hear from Mr. Warner as well.
Madam Chair, David Warner, Principal Counsel. So I reviewed the video from your November 21st meeting. Deborah Borden advised the board that the waiver and the request for reconsideration that were on the agenda that night, as far as the request for reconsideration goes, was not within your jurisdiction, because at that time, the preliminary plan that had been appealed to the circuit court, had been a request for judicial review to the circuit court, which had been denied, the applicant had submitted a motion for reconsideration at that time, which was pending in the circuit court as of November 21st. So Deborah advised you that it wasn't within your jurisdiction. The preliminary plan was within the jurisdiction of the circuit court. On December 9th, the circuit court denied his motion for reconsideration. He did not appeal the circuit court's denial of the merits of the preliminary plan of subdivision. So that is why the applicant...
You know that he did not appeal the merits of, because this is not what he's saying. He's saying he did appeal the preliminary plan, but you've seen the pleading.
Yeah.
Okay.
So,
Okay.
After the circuit court's decision on December 9th finalized your approval of the preliminary plan, he moved to appeal that motion of consideration, but not the preliminary plan.
Okay.
What the applicant then did subsequent to that was to request again the exact same request for reconsideration that you had waived the rules for on November 21st. So there was no need to waive the rules again for this meeting. All that's before you is the request for reconsideration. And as Mr. Benton notes, he identified the section of your procedural rules that are the grounds for granting a request for reconsideration. He notes that good cause is one of the reasons that reconsideration can be granted. And then the applicant has submitted the request with a basis for why good cause should apply in this case. Mr. Benton said he hadn't seen that, but that was in the staff report. So now this motion is within your jurisdiction to make because the preliminary plan is final, and the same request for reconsideration that was entered in November 21st is now before you, and the waiver that you approved is still active.
Okay, thank you. Okay, Mr. Rivera.
I think
And then I'd like to address some of the issues that Mr. Dean, Mr. Sam Dean has raised regarding the transportation. If you can shed any light on that, please.
Okay. Thank you, Madam Chair. Again, for the record, Norman Rivera. And Mr. Mazog is aware of the history as well. First of all, the reconsideration request does not have anything to do with the conditions relating to the proposed ramp flyover.
Okay.
So
Let's restate your request. Let's, for the record, to keep it clear, restate your request, your good cause, and your limited basis, and your limited request.
The request for reconsideration is based on good cause because the development caps have now been reduced from the time of the preliminary plan to the time of the DSP. So under the council of the planning board's county code, the rules of procedure under 27-270 require CSP, prelim, DSP. So at CSP, the staff report correctly indicates there was 404,000 square feet of commercial space. A preliminary plan was another reduced amount, and then at DSP, when you actually have users, it was again reduced. But the preliminary plan had X conditions, 6A and B in this case, that were based on the higher trip generation for the higher amount of proposed development. So the good cause is that the development requested was decreased over time. So Mr. Benton said there was a max development cap of this and this. You're not required to build the max. That's the max you can build. But as you go through the development process, it goes to whatever the board and the council approve, depending on which vehicle you're in. So at this point in time, the trip generation was reduced. Therefore, the transportation conditions for off-site road improvements get reduced, and that is the legal nexus. So in the case law, good cause was defined in various cases. So there are significant changes in conditions or circumstances for a particular case, and the body or the officer of the court that hears the reconsideration can make a decision based on the facts and the good cause presented to you. So that's your jurisdiction. The ramp and flyover was a creature of the master plan of transportation. It was in the old Largo Lotsford master plan. It was part of other plans. Mr. Dean and I think Mr. Benton referred to Woodmore Town Center, but there's a lot of Woodmores. This is not Woodmore Town Center. This is Woodmore Commercial, which is south of St. Joseph's. So there was a lot of route improvements associated with that very large project, and we have our own set of improvements. So we're not affecting Woodmore Town Center. Those improvements are their responsibility, and we have our improvements. The issues related to land use, the MXT zone was granted by the district council back in 2002 to rezone the property MXT. The uses of the Royal Farms or the apartments, those are all by right uses, which this board approved. Now going back to the ramp, if there was a ramp, as we went through the CSP and the preliminary plan process, the gentleman sitting to my left would have said, Norman, you've got to reserve or dedicate the right-of-way for said ramp, and there would be a condition of that ramp or flyover. There is not anywhere in our approvals. It was a consideration. The county decided there should not be a ramp or a flyover, or else they would have funded it, and others on the other side where Peppercorn Place is would have been required to do the same thing. So at the end of the day, we went to the county with Mazog, Public Works, DPI. We said there's a reference to this master plan road. Where do you think it should go? We all decided where it should go. The planning board approved a prelim plan and a DSP, and we deeded it to the county, and we have a permit to build it and a permit from State Highway to connect it to 202. So it's precisely the place that the planning staff said it should go after a preliminary plan review where you do that, and then it went to the technical agencies to make sure it's going to be permitted and built according to standard, and that's where we are today. So it's not a ramp or a flyover, but it was referred to as I-310, but there is a name for it. It's called Grandway Boulevard. So Grandway Boulevard was I-310. I-310 was deeded. Eventually, we renamed it Grandway Boulevard, and it connects Ruby Lockhart Boulevard to 202, so there's a vehicular connection for circulation. We also are completing Ruby Lockhart Boulevard going towards the shopping center to St. Joseph's. So now the folks that live in the area don't have to go up 202 and go in. You can come from Lotsford Road, go right through to St. Joseph's and into Woodmore Town Center if you want to go to Costco or whatever. So the housing is not an issue because the apartments are by right on MXT. A convenience store, gasoline station is permitted by right, and the other uses aren't before the board right now. Those are all DSP issues. We have not filed any application for any other users. So we're in conformance with the zoning, the CSP, the prelim. There is no ramp or flyover, and if there was, we would have seen it in one of our conditions. This is solely today to refine the conditions that are on the books to reflect the fact that our trips were now reduced. Thank you.
Thank you. Okay. Mr. Masog, do you have anything to add on that? I'm Mr. Lenhart, do you have anything to add? No. Do you want to go first? Okay, Mr. Lenhart.
For the record, Michael Lenhart with Lenhart Traffic Consulting. So I'd just like to clarify that I-310.
Can you raise it a little bit, the microphone?
Yes.
Thank you.
I-310 is a master plan road through Woodmore Overlook commercial property. As Mr. Rivera said, we have permitted it, we're going to build it. It's part of the master plan road network. It is discussed in some of the findings as part of, it's a connector road to the future overpass at 202 and St. Joseph's. If and when that ever gets built by other parties, the I-310 would provide a connection between 202 to Ruby Lockhart to the flyover at St. Joseph's. There was never a condition for us to do anything other than dedicate I-310 and build it within our right-of-way.
Okay, thank you.
So,
Does the board have any questions? Okay, Mr. Mesa, do you have anything else to add?
Tom Masog of the Transportation Planning Section. Just to talk a little bit about this master plan road. This particular master plan was under development before I even started working for the commission.
A little while, okay.
So that's some time back there. And so
With the
it's a
dark
matter
curly
of
hair, okay.
interpreting what was intended by the plan when it was developed and put down on paper. The applicant came with a proposal to put I-310 through the middle of their property and connect to 202. That, in my mind, fulfilled the function that was, for which the road was placed on the master plan. And so we found that to be consistent with the master plan during review of the preliminary plan of subdivision. And so as everyone knows, we develop these master plans. They are approved by the council, but over the long term, they are implemented by the county or the state, whichever is the responsible road agency. And so to answer the question very directly, does DPI determine master plan roads? Well, no, it's the district council that does so through the approval of the master plans, both the area master plans and the functional master plans. But DPI absolutely holds the authority to permit that road. You, the planning board, get the dedication through the preliminary plan of subdivision process. Once we get that dedication, once you and I work together to get that dedication, then it's the county's or the state's responsibility to determine what to do with it.
Thank you. Okay, Mr. Benton, succinctly, and then we're
Wait,
going.
I'm sorry, Madam
Yes,
Chair,
I'm
I just wanted to add one little thing to
Okay.
what Mr. Mazak pointed out. The master plan roads, they're conceptual in nature. And numerous times, they end up being not exactly where they appear on the map because it's not to scale. Those maps are not to scale. It's a conceptual plan, and depending on a lot of things, topography, environmental issues, what have you, they may have to move one way or the other.
And the district council does the master plan?
Right.
Master plan roads.
We create the plan, the board adopts the plan, and
But it's
then
ultimately approved by the.
the council approves the plan.
Okay, okay, and then the pertinent county DPWT or SHA will do the permitting? Okay, okay, Mr. Benton, succinctly, okay.
My request is simply this. Currently, there's a discrepancy as to what the merits of my appeal are, right? And obviously, y'all haven't, the board hasn't had the opportunity to reveal what the merits of my appeal was for the specific determination of jurisdiction, right?
That's not our
What I'm,
jurisdiction.
all I'm simply asking is, okay, before you make a decision to, let's say, potentially award or approve the reconsideration, allow the staff to go through, right? Can we pass or forward the decision over to the next planning board meeting?
Well,
That
I
way-
think, I'm sorry, go ahead. That's your request to pass it. I think, I don't know that there's a sentiment to do that. What I am going to do is, you know, as Mr. Dean knows, when the council sits, when the county council or district council sits at a hearing, when a legal issue crops up, not every single council member is going to review the legality. What they're going to do is they're going to turn to their counsel for that review. Same thing with us here. Now, we have attorneys on this board, but not all of us, but some. And rather than wear 3 and 4 hats up here, we heard from our counsel, and our counsel has an opinion on that, which apparently is different from your opinion. Okay. So, okay, Mr. Dean. This is the request for reconsideration.
I mean, to get beyond this mess, there was a hearing before the district council on September the 17th, 2019. And the issue that we're dealing with, we're dancing around all this mess. What we're dealing with is a ramp. The district council heard the applicant, and they rendered a decision on September 17, 2019, that state the applicant shall revise the site plan to show I-310, the ramp, Lincoln, Ruby Lockhart Boulevard, and Maryland 202. Also, in zoning ordinance number 6, 2010, okay, it states very clearly that
Are you
all
saying section
future-
27?
Huh?
Section 27?
16, zoning ordinance before the district council, zoning ordinance number 6, 2010. And I happened to be on the council at that time. It states unequivocally that the conceptual site plan shall show right of way along I-308, Ruby Lockhart Boulevard, and I-310, the ramp, Lincoln, Ruby Lockhart Boulevard, and Maryland 202, consistent with the master plan recommendations. The right-of-way shall be shown for the dedication at the time of preliminary plan of subdivision. And
What year was that?
it was 2010.
2010, okay.
Okay? And the issue for us is that most members in the community have no clue about this stuff. And they would have to compete with Norman Revere, who I know, respect, and they're up against it. The other thing for reconsideration, you gave them 6 parcels. They identified 2, one for the rental and one for the rural farm. We don't know what's going to happen to the other 4. They're going to tell us maybe 2 or 3 years later when they build it out, which would be a strip mall. And again, I'm so passionate about this because I live in that community. And the last thing in the world I would want for my investment to go down the tubes because we have strip malls around here. So the reconsideration request is really basically about the ramp. No other reason but the ramp. And the question becomes, we can come back and go through this stuff again, but it's going to always be about the ramp. The only thing I also ask, and I heard Mr. Mazoff, does DPI have the authority to determine master plan road? Secondly, why did the developer give the county land that is being used to make that master plan road? The community was not aware of it. The community, I repeat it, was not aware of it. And I think that you all do us a disservice if you allow this project to even consider reconsideration. We made a decision at the district council, and that should stand. Thank you.
Okay, thank you.
You have any questions?
Are there any questions? Thank you.
Thank you.
Are you trying to add something or no? Okay. Okay, so let me say this. I hear what everyone is saying here. I think we all do. We listen intently. I have to tell you, to me, the case is being made for the reconsideration request because I'm hearing things that I'm wrestling with and I don't have clarity. So I'm hearing particularly Councilmember Dean, former Councilmember Dean, talk about the 2010 decision of the District Council reflecting, addressing the CSP, showing the ramp, and I don't know how this all fits together. And so the only way I know how this all fits together is if we actually have this hearing on the substance of this. You know, we're talking about this limited request for reconsideration. From Mr. Dean's standpoint, it's the ramp. It's all about the ramp. It's always been about the ramp. We've had issues regarding DPI and SHA and the concerns raised by Mr. Dean with regard to DPI's authority. I don't know. We've heard from our counsel with regard to the appeal of the circuit court's decision not to reconsider their decision on the preliminary plan. And I just think there's, the only way we can address all these things is if we actually hear it on the merits. We've gotten deeper into the merits than that we intend to do at the request, but so many things have been raised here. And Mr. Rivera has also mentioned about the reduced trip cap. So the only way I can address it is to actually have more information on the substance of it. And I don't know what anybody else feels. So was there anything else? Nope. Is there a motion?
Madam Chair, associating myself with your comments, I move that we approve the reconsideration for preliminary plan 4-18007, based on good cause, and that it be limited to conditions 6A and 6B.
We have a motion to grant the request for reconsideration. It was the request. Limited to conditions 6A and 6B of the preliminary plan. Is there any additional discussion?
Under additional discussion, I'll just also associate myself with your comments that we've got a lot into the issues of the case. When this comes up for reconsideration, please be organized.
Yes.
This has been not a waste of time, but it has been extremely repetitive today. This could have been a very easy case that we could have just granted the reconsideration, and then the merits of the case and the substance could be asked and answered and discussed later on. I've heard the same thing over and over and over again today, and it has nothing to do with the reconsideration. It's the substance. So when we get to the substance, I don't want to hear over and over and over again the exact same things. So succinct arguments make it a lot easier for us to make the decision whether or not we rule in favor of the applicant or against them. Hearing them over and over again makes it kind of confusing. So to the extent that we can be very organized, that would be extremely helpful for us to make our decision.
Madam Chair, I would like to associate myself with my colleagues' comments because I was fluctuating between, are we talking about the reconsideration or are we discussing the case? So it was kind of hard for me to follow. And so the reconsideration gives us an opportunity to delve a little bit more into the limited substance of the case.
And I would agree with Commissioner Dorner. It's really imperative that everyone come in here with the specific issues, addressing the specific issues that are the subject of the request. Okay, we have those two conditions, and Mr. Rivera, be prepared. You should have had your conversation with Mr. Harding by this time. You will have. We have our decision from our legal opinion from our legal counsel. You know what? And I'm gonna peek at the pleading myself too. Okay, and we're in the middle of discussion though. Can it wait till afterwards? Okay. And we just need to limit. We need to be more organized because we got way into the substance here. So. All in favor of the motion indicate by saying aye.
Aye.
Opposed? The ayes have it. Thank you. Mr. Dean, you had a comment. it's not on the record of this case, because we're done with that. Okay.
For us to be prepared
Uh-huh.
to come before you. I'm a citizen, and my issue is that I'm not an attorney. I'm coming and presenting what I have.
Yeah.
I need to get two things from you, Madam Chair. One, how did the property that was transferred from the developer to the county, how was it done, who signed it, and was there any hearing? This is very important. The second was that I need for you to provide me with the authority that DPI has for determining master plan roads.
Okay, so we will look into that, but it's basically the council, you said, that decides the master plan roads, and right? No?
The district council.
The district council does decide the conceptual area.
Correct, you said
of
conceptual in nature, but there's some flexibility.
But the operating agency and the planning board and the council, through the development review process,
Have some flexibility.
determines the actual location, because when the plans are done, when the master plan is very
Okay.
high level, and you don't know what you're dealing with
Got it.
on the ground.
Got it. Mr. Dean has made a request. It's outside of our purview, but to the extent that you can put that, provide that information for him, that would be helpful. Okay.
Thank
Okay,
you, Madam
thank you.
Chair.
We have before us item 3A. We have CB 5/2020.
Good afternoon, Madam Chair. Raina
afternoon.
Hightower, Intergovernmental Affairs Coordinator for the record. CB5 would exempt land used as, for medical cannabis dispensary from the minimum setback requirement of 500 feet from any park and planning property if the land is located near the northwestern branch stream Valley Park, or the land was conveyed to WSSC. This bill seems to permit a special exemption without any explanation. There are other properties near other parkland sites that would be required to comply with the 500-foot setback
You have a great
requirement.
recommendation here. Are there any questions?
Yes.
I move that we accept that great recommendation, staff.
Second.
We have a motion and a second. It's well put, I'm sorry.
Very well.
All in favor indicate by saying aye. Aye. Opposed, the ayes have it. Mr. Hunt, is there any additional business to come before planning board today?
No more items before the board today, Madam
Okay,
Chair.
I will say happy Valentine's Day to everyone.
Happy
Planning board is
Valentine's.
adjourned.